We're going to start with a legal statement based upon some of the legal questions that were provided to us, and then we'll move on to addressing, tearing down from there. So,
Thank you, Mr. Chairman. Ladies and gentlemen, my name is Jeff Mando, an attorney. I'm from Northern Kentucky. I've been representing public entities for close to 30 years, and I've represented library districts and currently do. What brings me here today, and the reason the board hired me, just so we're all clear, is that there was a direct letter that said that if the board was not in full compliance, they were prepared to begin litigation via class action. And that's the reason the board contacted me and hired me. I think any reasonable person, any reasonable body, any reasonable business, when faced with a letter like that, would perhaps consult with a lawyer about what their rights are and what they should do, just what you would do if you received a letter like that. And that's the reason I think this situation tonight, the reason this discussion has become somewhat adversarial. Now, just because that happened doesn't mean it has to stay that way. I'm a defense lawyer. I do not sue other people generally. 95% of my work is defending entities and bodies and people. I'm all about trying to come to reasonable solutions through dialogue and constructive ways to avoid conflict and litigation. Because whoever said it right, when you get into litigation, the only folks that are going to get paid money are going to be the lawyers. And that's just a fact. So if there's a way to resolve this, and there's a way to do it in a constructive manner, I'm all about advising the board to go down that road. Now, with regard to the questions and the tax rate in particular, with regard to the questions, those came at the same time, as I understand it, as the letter did about the threat of litigation. So the question, and I as a lawyer, doing my duty to my client, have to look at those questions through the lens of a lawyer before I tell my client what to do. And I think the staff here is going to do exercise their best effort to give you the documents and information that you asked for, that you're entitled to. Even though your letter wasn't codified or called an open record request, I construe it as such, and I think the board and staff are going to get you these documents you asked for, and they're going to do their best to try and answer your questions. With regard to the tax rates, let me speak to that. Throughout the letter, throughout the questions, there's a presumption in a number of the questions that the board has been illegally assessing its tax rates for years here in Montgomery County. The letter doesn't specifically say why, and it doesn't go into the details, but the implication is because of KRS 173-790 that somehow controls the situation, and the board could not and should not, and it was illegal to raise an ad valorem tax rate ever since the board was formed in 1980. Let me tell you that I don't believe that to be the case. The reason is KRS 173-790, which talks about library boards setting tax rates for libraries that are formed by petition. It says generally that you have to go to 51% of the voters who voted in the last election to have them sign a petition. The problem is that statute was adopted in 1964. In 1979, the General Assembly changed the game. In 1979, the General Assembly passed House Bill 44. You've probably heard of it. And it's been codified in KRS 132. And what that did is the General Assembly said, you know what we're going to do? We're going to try and handle this situation with inflation back in 1979, if anybody remembers. And we're going to put this control in place, okay, because of the inflating house values, to try and control the tax revenues and try and get some budgets in order. So House Bill 44, it was passed in 1979, applies to all taxing districts. And it says that you can there's limitations on what you can do. And there's the compensating rate. The compensating rate is is the tax rate that will generate the amount of revenue that the library board received in the prior year. So the compensating rate is a way for boards to get the amount of revenue that they had in the past year, and if they go beyond 4%, if they want to try and raise more than 4% of the revenue that they had in the preceding year, then that's subject to a voter recall. So that gives the power back to the people to try and say, hey, we don't think as a community that you should go beyond that particular rate. Those are the controls the General Assembly put in place in 1979. Once that was done in 1979, the Department of Local Government in Frankfurt then started calculating, going through the formulas for all the taxing districts, and then through the Kentucky Department of Library and Archives, the Kentucky Department of Library and Archives were advising, based upon the information from the Department of Local Government, all libraries in the state, that they were subject to House Bill 44. That started in 1979, shortly after the legislation was passed. So for over 34 years, libraries across the state, all 78 that have been formed by petition, have been complying with House Bill 44 that was passed in 1979. And attorney generals have rendered opinions that that's the way it works. The General Assembly has had multiple opportunities since 1979 to change the statutes if they felt that libraries weren't subject to House Bill 44. If they felt that they were somehow carved out, they would have taken it out of that. But they didn't do it. The General Assembly has not seen fit to do it. In fact, if anybody's familiar with House Bill 1, which was just passed by the General Assembly last week? Last week, that the language in there further supports the proposition that I just outlined for you, that the library districts across the state, by complying with House Bill 44 and the limitations that it has on setting tax rates, are perfectly legal and legitimate. So that's the short answer, and I know there's probably a lot of legalese in there, but the suggestion that 173-790, the 1964 statute, somehow prohibited this board and boards in the past from raising or setting the ad valorem tax rates, I just don't believe is valid, given that legislative history, the Attorney General's opinions. There's even case law that talks about these particular issues. Now, I know everybody's aware that there's a lawsuit up my way, okay, and we're in litigation up there. It's been fully briefed. It's involving Kenton County and Campbell County Library Boards, and they have a different view of the world. I'm just trying to tell you legislatively, historically, what the position is and what my take is on the situation at the present time. So to answer your question about the tax rates, I hope I did that. But with respect to the questions that ask for information about cardholders and historical information about the library, my understanding is staff is gathering that information and is going to provide it to you.